Assalamu alaikum and welcome to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia and I'll be with you for the next hour. As our regular viewers are aware, the free legal advice show provides you, our viewers, the opportunity to call in and ask us any questions that you have on any aspect of English law. On this show, I'm able to cover a vast diverse range of matters ranging from immigration law matters, family law matters, criminal law matters. So whatever your legal questions are, please do get in touch. Two ways to get in touch. You can ring us on the landline number which appears at the bottom of the screen, or alternatively, a very popular way of getting in touch is to send us a message on the mobile number which also appears at the bottom of the screen. So the landline number for live calls and the mobile number for text messages, WhatsApp messages. Any messages that you send through today will be sent through to me here live in the studio, and I will be able to address your questions live on air. A couple of minor points before we get going. If it transpires that your question is quite complex or I need to look at documents, then I will ask you to leave your number with the control room, and I will then give you a ring off air, and then I can have a more thorough discussion with you off air. And this is a service that we provide completely free of charge. Whether it's advice that I provide to you live during our conversation, or whilst I deal with your text messages during the show, or whether it's something that I need to look at after the show, look at your documents, have a more thorough discussion with you. Even if that's the case, that's a service that we provide completely free of charge. So please do get in touch. And as I said earlier, it doesn't have to be immigration law. Immigration law is a very popular subject. It doesn't have to be immigration law. Other subjects, criminal law, family law, personal injury matters, whatever your legal questions are, please do get in touch, and I'll try and give you some practical, proper advice, at least something for you to take away, something for you to ponder, something for you to consider. Now, with the intros now out of the way, let's look at some of the questions coming in. The first question that's come in is from Sabina. Slightly unusual question, because we don't really see these questions very often nowadays. Her question is, can you sponsor somebody to come to the United Kingdom in order to help with your housework, such as a domestic worker? Now, I can see where that question is coming from. Domestic worker used to be quite a popular category for certain types of people, where they used to call from abroad, they used to call their drivers to come to the UK, they used to call their cooks to come to the UK, they'd call their nannies to come to the UK and try and help with work that needs to be done within the person's household. So that was a category which could be used and was used before. To be quite honest, nowadays it's not something that you can really use. There are very limited circumstances in which you can sponsor a domestic worker to come to the United Kingdom. It's really where a British family lives abroad and they have a number of workers who live with them, and whilst they come to the United Kingdom, they want to bring their workers with them to the United Kingdom for that short stay here, and then they would obviously then go back, and the workers would go back as well. So in answer to your question, Sabina, it's highly unusual now to see a domestic worker application. But thank you very much indeed for that question. The next question that's come in is from Abdullah, and his question is about nationality. Let's look at the question he sent in. Okay. He says, Assalamu alaikum, brother. I submitted my children's nationality application to the Home Office. The application has passed the 6-month time frame. They haven't let us know what's happened with the application or whether they need time. This is causing a lot of issues for me. Is there anything I can do? Now, Brother Abdullah is asking a question regarding his children's nationality application, which was submitted 6 months ago. He still hasn't heard anything. They haven't got back to him. They've not said to him we need more time to consider the application. Nothing of that sort. What can you do? Well, look, it's not, starting point is this, it's not unusual for the Home Office to take 6 months to process an application. They have become faster nowadays in terms of processing nationality applications, child registration applications. You tend to get a decision now within around 3 to 6 months. So I accept, compared to what the situation was historically, the Home Office is now much quicker. However, having said that, Brother Abdullah, 6 months is still not a very long time. Now, if it's the case that you've had nothing at all, what you could do is email the Home Office and see whether they provide you with an update. If you still don't receive anything, a couple of months go by, you still haven't received anything, you could submit a complaint to the Home Office. They may look at the processing of the application and get back to you. If the complaint doesn't resolve things, then you could potentially speak to your local MP and ask your local MP to get in touch with the Home Office to see why it's taking so long for the application to be processed. So there are a number of things that you can do to try and push things along, from emailing the Home Office or writing to the Home Office, to submitting a complaint, to possibly speaking to your local MP and getting your MP involved to try and push the Home Office to make a decision. But I'll go back to what I said initially when I started answering your question, which is that in terms of nationality applications, child registration applications, 6 months isn't that long actually. The Home Office does take around 6 months, 6 to 9 months to process applications. I know they've got quicker recently. We've noticed that at work. We're getting decisions back. Some are coming back within 2 to 3 months. Generally, 3 to 6 months is a good guide at the moment. But having said that, there are cases which fall outside that all the time as well. So you could try and push them along to try and make a decision. In the end, as far as the Home Office is concerned, as far as processing times are concerned, I'd be honest with you, there's nothing unusual with the time frame you've mentioned where you've been waiting for 6 months. There's nothing that unusual for the Home Office. But thank you very much indeed for that question. Now, next question that's come in is from Sister Memuna, and she says as follows, that let me just read her question. Memuna says, my granddad needs to apply for settled status. He has a Pakistani passport, but he moved here through my dad, who has Italian nationality. How do we go about applying for settled status for my granddad? Okay. Now, somebody who's come to the United Kingdom, sponsored by an EU main applicant, and they're entitled to sponsor children, parents, grandparents. And here what you have is a son who has sponsored his dad to come to the United Kingdom. And in that situation, what happens is, once somebody's come to the United Kingdom under the EU settlement scheme or under the previous European scheme, and they've been sponsored by their child, so the parent, so the son sponsors the father. Once the person comes to the United Kingdom and they have completed 5 years in the United Kingdom, they are then eligible to apply for settled status. Effectively, that's permanent stay. So they're able to apply for settled status at that stage. Now, the key thing is that the person that's been sponsored to come to the UK must complete 5 years in the United Kingdom. So look, that's the starting point. And I think from what you're saying, Memuna, your granddad has completed 5 years in the United Kingdom. The question then really is, you still have to prove that you've lived in the United Kingdom for 5 years. Now, as far as that proof is concerned, the Home Office wants to see actual documents such as letters, official letters coming to him at his home address, doctor's letters, medical records, could be bank statements, could be benefit letters. So the problem sometimes with these applications is that although in your situation the person might have spent 5 years in the United Kingdom, sometimes that's not sufficient. 5 years isn't, so it's not that you've spent 5 years in the United Kingdom, that's just a starting point. You have to prove that you've spent 5 years in the United Kingdom. Now, somebody who's worked here, they are in a more fortunate position because they would be able to prove their residence simply by the Home Office checking their HMRC records. You would have got pay slips, you would have paid tax, you would have made national insurance contributions, and that would all be with HMRC, and the Home Office has a link with HMRC and they're able to check your tax records. And if your tax records show that you've been working for 5 years, that then automatically demonstrates that you've been living in the United Kingdom for 5 years. So that's fantastic. The problem is that where the person who's been sponsored to come to the United Kingdom is an elderly person, in that situation, it's unlikely that that person's worked, or unlikely that they've worked for the whole 5 years. So the difficulty then is we're trying to look at other documents to try and prove the person's residence. As I said, it's got to be documents such as bills, gas, electricity, water, telephone, TV license. Council tax is a very good one. Or it could be doctor's medical records, or it could be bank statements that if you opened a bank account, fantastic, and you've used your bank account, you're going to have bank statements from the time you opened your bank account. Now, the good thing is that the Home Office doesn't ask for loads of different types of documents. You could have a bank statement which proves your residence, 10 bank statements which are where the account has been used could potentially prove 10 months of your residence in the United Kingdom. So it's not one where they insist on a variety of documents, but at the same time, you do need to prove your residence in the United Kingdom, especially if you have not worked in the, and that's where the problem occurs. So in practice, immigration solicitors will say, well, a lot of people will come to their office and they're saying, look, we've been here. A lot of people came to the United Kingdom when it was COVID. So if they came around February, March 2020, that's been 5 years since we had COVID. And if they came to the UK around that time, they may not have opened their bank account straight away. They might not been able to. They might not have been able to register with the GP straight away. They might not have gone to work because most businesses had stopped operating. A lot of employees had been furloughed. So there's a particular problem with people applying for settlement now, where you're having to prove 5 years of residence. It's that 2020 period where there may not be many documents proving, which will assist in proving your residence. But in a nutshell, the point is this. I understand what you're saying, that your granddad has completed 5 years in the UK. What you now need to do, even if you're doing it yourself or you're going to see a solicitor to do it, what you need to do is really look at whether you've got proof of residence in the United Kingdom. Really, that's what you need. Now, worst case scenario, if you don't have it, if the Home Office said, look, you can't be satisfied, you've been here for 5 years. Yep, we're satisfied for the last 3 years. Look, with most people who are here with pre-settled status, they've had their visas automatically extended for a couple of years. So you could make that application a little later on when you're sure that your evidence of residence for the 5 years, the previous 5 years, is more easily and properly covered. But thank you very much indeed for that question. Now, the next question that we've got is from Zara, and that's regarding a nationality application. And what she says is that my mother wishes to apply for British nationality. She is now 57 years old, grew up in Pakistan. She finds it difficult to pass the English test and the Life in the UK test. She has a number of illnesses. Can she be excused from the English test? Now, Zara, that's a question that comes up in practice quite often. There are certain circumstances in which, when you're applying for nationality, you can be exempted, excused from having to do the English tests. But these exemptions, the way they are considered in practice, unfortunately, are such that the Home Office takes a very restrictive approach in terms of who they will allow to apply for nationality without having passed these tests. The way to do it is to get a number of different pieces of evidence. The starting point is that Zara, your mum will need to submit the medical exemption form that the Home Office has on its website. Literally, it's a 2-page form, and the doctor will need to confirm on there what her illness is and why she's unable to pass the English test in the GP's opinion. Look, that's the starting point. That's what you need to begin with. In addition to that, what I tend to submit is the medical records as well. The reason I do that is sometimes the Home Office will say, when you've applied for an exemption and they've refused it, they said, well, you completed the exemption form and sent it to us, but you didn't submit medical records. We expect to see medical records. You didn't get a doctor's letter. So it does require more work than simply submitting that medical exemption form, which is very, very basic indeed. You do need to submit, if possible, the medical records. You need to look at the medical records to see what they say. Do they support your case that mother is unable to pass the English test? Does it deal with her illnesses, her problems, etc.? So that's one thing. Well, medical exemption is the first thing. The second thing is the medical records. The third thing I would get is a GP's letter. If not a GP's letter, then another professional person's letter where they confirm why you are unable to pass the English test. It could be a social worker who's assisting. It could be a mental health expert. It could be some other expert who can properly comment on a mother's ability to pass the English test. Now, what I find sometimes is this, that the GPs aren't very good at doing reports. It could well be that you could get a report from a psychiatrist or a psychologist who can actually carry out tests and confirm whether in reality it is possible for mother to pass the test or not. There might be an issue with learning disabilities, etc. So sometimes going beyond what your GP can give you, going to another expert may get you that crucial piece of evidence that you need to try and get the medical exemption through. So Zara, that's a situation. If there is a mental illness, a disability of some sort which prevents your mother from passing the English test, and with evidence you can prove it, medical exemption from medical records, an expert's letter or a report, if you can prove that your mother cannot pass the English test, then yes, potentially she can be exempted from the B1 test and the Life in the UK test. But thank you very much indeed for that question. Now, The next question that's come in relates to the English test that you need in order to extend your visa in the United Kingdom. And it's from Sister Shamila. And let me just read the question out. Sister, Assalamu alaikum. I have an English test, which I did whilst I was abroad. Would you be able to confirm whether the test is acceptable or not? The test is a Pearson test. Now, it's difficult to confirm just based on that whether that test is going to be acceptable. What I can do is give you some general advice. What you've got to understand is there are only certain types of English tests which are acceptable for UK visa purposes. And here we're talking about a spouse application, here we're talking about an extension. It could be the initial application, it could be an extension, it could be an indefinite application, it could be a nationality application. The point is this, that people do various different courses, people will do various different tests. They may be at a lower level, they may be at extremely high level. But only certain tests will be acceptable. So if I give you an example, a lot of our viewers might be familiar with the test, IELTS test, IELTS test, which a lot of people have to do when they come to the United Kingdom. It's a test which is accepted worldwide, and it grades your level of English, whether it's speaking and listening, or speaking, listening, reading, writing. But even when it comes to that test, it has to be a particular kind of IELTS test that the Home Office will accept. So you have to look at whether the test you've done is acceptable as far as the Home Office is concerned. And really, there's only about 4 or 5 providers that the Home Office will accept a test result from. Different providers, if you're applying from, if you've done the test from within the UK, and there are some different providers where the test has been done abroad. But there are certain limited test providers, and even with those test providers, there are certain limited tests that will be acceptable for the Home Office, whether it's an initial application, an extension application, or indefinite application. So that's what you need to bear in mind. Now, what you've got to do, you need to go onto the Home Office website, and the Home Office website will tell you which tests from within the UK, which tests from outside the UK are acceptable as far as these applications are concerned. Now, you've mentioned a test, Pearson test, and I can say to you, Pearson tests are acceptable. So the provider, the test provider, Pearson, their certain tests are acceptable. Off the top of my head, if it's a Pearson test, it has to be a Pearson PTE Academic UKVI or a Pearson PTE Home. So that provider will have a number of different tests that it administers for people. But as far as the Home Office is concerned, they will only accept certain tests. And as far as Pearson is concerned, off the top of my head, it's the Pearson Academic UKVI and it's the Pearson PTE Home, which is acceptable. So whatever test you've done, and for the benefit of our viewers generally, if you've done these tests and you think it might be acceptable, check on the Home Office website whether it's actually acceptable or not. So thank you very much indeed for that question. The next question that's come in is from Brother Noor, and he says, on my birth certificate and on my siblings' documents, my father's name is spelled differently to the way it is spelled on his passport and ID. his name is the same, but it's spelled differently on the birth certificate when compared to how it's spelled on the passport and ID document. Same name, different spelling. So, if I was to sponsor my dad to come here, will it cause a problem? So I understand where you're coming from. The big issue is the difference in spelling between the spelling of the name on your birth certificate and the spelling of the name on the passport. Now, it can cause an issue if it's a European application that you are submitting on behalf of your father. So if you're sponsoring your father to come to the United Kingdom, you're an EU national, they are quite strict about the spelling of names, etc. There are, in my view, two ways of dealing with this particular problem. You can either get a letter from the authorities back in your home country. So for example, there would be, if it's Pakistan, I think it's the Union Council that deals with these kind of matters. So you get a letter from them explaining that based on your records, the person who's named as the father on the birth certificate, the person whose ID document has this name but spelled differently is the same person. And it just so happens that the name is spelled differently. It's very common because what happens is the names are spelled in the language of the home country. So if it's in Pakistan, it'd be in Urdu. And then somebody is then writing the English version of that when you get an English version of that document. And when you get an English version of a document, different people can spell the name differently. Even when we look at something very basic, like the name Muhammad, even that can be spelled in a number of different ways. And that's a problem across the board with names. So what I would do is, number one, if possible, prove that it's the same person, get a letter from the issuing authority confirming that it is the same person. Number two, if you think that it could be a major problem, then, and you think, you know what, you don't want to take any risks at all, get a DNA report that will, and it's a DNA report from the approved DNA test provider. Again, it's got to be an approved company as far as the Home Office is concerned. Get that DNA report, that will then prove. Now, in most cases, you won't need to go that far. Minor spelling, letter from the authorities, or there'll be some other way of proving that it is the same person. But if you've got real concerns that, you know what, there's a couple of mistakes here, it doesn't look right, just get a DNA report at that stage. But that's the second option. The first option is try and get a letter confirming it's the same person. It's just that the name has been spelled differently. So I hope that answers your question. Now, the next question we've got is from Brother Ashfaq. Let's have a look at Brother Ashfaq's question. And what Brother Ashfaq is saying is, I say, Assalamu alaikum. I'm calling a message in from Bolton. I am on the 10-year route to settlement. My 10 years finishes on the 21st of January 2025. Am I able to apply for indefinite leave to remain? What is the process? What are the documents that are required, and how much will it cost? Okay, now, a lot of people are on the 10-year route to settlement in the UK. It could be that somebody has various different types of leave that's been combined in order to get indefinite leave to remain in the United Kingdom. Now, the point is this, that if you've completed 10 years in the United Kingdom lawfully. So you've got no breaks in your 10 years. You've applied in time, one after another. So you've got 10 years of lawful residence in the United Kingdom without a break. Then you can apply for indefinite leave to remain based on your 10 years lawful residence. Okay, so that's the starting point, Ashfaq, that potentially you can apply. And you can actually apply 28 days before your 10 years are completed. But that's, I think, you're coming up to actual 10 years anyway. So can you apply? Yes. What is the process? The application that you submit is Form Set LR. So it's an online application that you submit, Form Set LR. What are the fees? The fees are £2,885, so just under £3,000. It's not a cheap application. You need to get together that kind of money to submit the application. Now, I think the main thing then is, what type of documents do you need to submit with your Set LR application? Document-wise, the application actually is not too bad as far as applications go. You would submit a copy of the whole of your passport, every page of your passport covering the last 10 years, because the Home Office will look at that to see your absences from the United Kingdom. They will want to see how long you have been outside the United Kingdom. It does have a residence requirement, quite a strict residence requirement, so you need to make sure you don't exceed that. But document-wise, you submit your passports for the period over the last 10 years. In addition to that, what I tend to do is, if you're married, submit the wife's passport. If you have children, submit that. Look at what type of application you currently have a visa under. So if you're in the UK at the moment, based on being with your partner and your children, include evidence of your partner and your children, and include evidence that you are still with your partner and your children. Sometimes the Home Office asks about that. The other key thing really with a long residence application is that you do have to pass the English tests. So just because you've completed 10 years, it doesn't mean the English tests don't have to be done. The B1 test, the Life in the UK test, still has to be done even under the 10-year mark. So the key thing is, once you've completed 10 years, you can apply using Form Set LR. You will need to prove that you've not, if you've been out of the country, it's within certain limits. And the Home Office will want to see normally your passports for the last 10 years, every page in your passport. Make sure the absence limit isn't exceeded. And the key thing is, you will need to pass the English tests unless you are exempt. And you're looking at fees of around £2,885. So again, quite a hefty fee, but the best thing is, if you do qualify, it does mean that you are now heading towards the end of your immigration journey. Now, before I move on to the next question, I should mention one more thing, that once you get your indefinite leave to remain in the United Kingdom, you then need to look at whether you are going to be able to apply for British nationality. When can you apply for British nationality? It depends. If you're married to a British citizen, you can apply straight away. That's the advantage. If you're legally married to a British citizen, you can apply for nationality straight away. If, however, you are not married to a British citizen, so a person could have citizenship of another country, whether it's India, Pakistan, Bangladesh, whatever it is, you would then have to wait 1 year after getting your indefinite leave before you can apply for nationality. So that's the difference. married to somebody who's British, you can apply straight away. If you're not married to somebody who's British, then you're going to have to wait 1 year before you then apply for British nationality. But other than that, as far as the nationality application is concerned, to be quite honest, there isn't much more that you need to do in terms of requirements. It's a fairly straightforward application at that stage. But thank you very much indeed for that question. Next question that's come in, slightly complicated, is from Akib. And Akib says, Assalamu alaikum. Wanted to ask, when I apply for wife's indefinite, can I be employed and self-employed at the same time? So I've been offered a job, but I would still be doing taxes on the weekend. Can I rely on employment and self-employment, the income from that, for wife's indefinite application? Right, so can you rely on employment income and self-employment income when you apply for your wife's indefinite leave to remain? The answer is yes, you can, but the way it operates is slightly more complicated. Let's assume, for the purpose of your question, that you are self-employed, you're a sole trader. Most people who are doing taxi work would normally be sole traders. They don't normally operate through a limited company, which is fine. So if you're a sole trader, and we're assuming that, then whenever you apply, you would have to rely on the previous year's, previous full financial year's income. So if you were applying now, we're in January 2025, and you're applying now, you would have to show income during the year April 23 to April 24, because that's the full last financial year. In that year, you can show your taxi income. In that year, you can also show how much you have actually been earning from your employment. So if I give an example, from taxes, let's say April 23 to April 24, you've made a profit of £12,000 as an example. You've made a profit of £12,000. You're now a bit short, you're £6,800 short in order to qualify for your wife to qualify for indefinite leave. If you've earned that amount of money from employment, so let's go back to April 23 to April 24, that financial year. If you've earned that amount of money, then you can combine both, and that would meet the financial requirement. Just one extra point, just to confuse matters, complicate matters a little more. Although you've got your income from April 23 to April 25 from your self-employment and your employment, we are now in January 2025. We're now some 8-9 months down the line. So we still have to prove that, not the amount, we still have to prove, yes, I am still employed and I am still self-employed, in order to be able to rely on those that income for that period. So you prove and you calculate your income for that period, but you also show that your self-employment and your employment is continuing. So that's what you need to do. So, Akib, in answer to your question, yes, no problem at all. You can rely on your employment and your self-employment income in order to meet the financial requirement for your wife. Now the next question that's come in is from Nadeem from London, and he says, Assalamu alaikum, can I ask a question regarding my employee who is a student who has been contacted by the university, who has told him that as he has not been coming to study, they are going to cancel his visa. Now, Nadeem, this is a very common question in practice. We have a lot of students from abroad here in the United Kingdom. For whatever reason, they are unable to complete their studies, whether they find the studies too difficult, whether it may be they can't afford to pay the university fees. Sometimes they've fallen ill and they can't continue with their studies, whatever the reason is. And the Home Office will then say, we are going to cancel your visa. Well, actually, they can't cancel your visa. It's not within the power of the Home Office to cancel anybody's visa. What they can do is remove you from the course. That's fine. They can do that. They can say, you are no longer a student at our university. They can remove access to whatever you have, the portals, etc., access to their buildings, etc. Fine. They can do that. That's within their power. They can also inform the Home Office that they are no longer sponsoring you. Then the Home Office has the power to cancel your visa. Now, the reason I am emphasizing this, the reason I'm making this clear is that sometimes when students get notification from the university, it says your visa is going to be cancelled, you need to leave the country, or you need to apply for another visa within 14 days. There's nothing like that. The process takes much longer than that. So, Brother Nadeem, yes, the student who works for you has received, no doubt, an email saying he is no longer a student at the university and they are going to inform the Home Office. Fine, that is within their prerogative to do that. When they inform the Home Office, that takes the Home Office 3-4 months to actually cancel the student's visa. The Home Office is inundated with these type of requests from universities, etc. So it's not the case that the visa will be cancelled immediately. The whole process takes around 3-4 months for them to action that request. And even after they've actioned the request, what the Home Office will say to the student is, we've been informed by the university that they've withdrawn your sponsorship, we're therefore curtailing your visa, and you've got 60 days now to, leave the country or make another valid application. So the point is this, that when a student receives a letter from a university, it's natural for them to panic, thinking, the world's coming to an end straight away. I need to leave the country by the end of the month. That's not the case. There is more time. And the key thing with these things is, look, they're here in another country with limited support. Time gives them the opportunity to adjust to their new circumstances. It gives them the opportunity to look at what else they want to do. So the key thing is we have time. The Home Office will take another few months to write to the student saying the visa is going to be cancelled. And even when the visa is cancelled, the student is given 2 months notice of cancellation. So in total, in my view, you're going to have at least around 5 to 6 months, if not longer, before your visa comes to an end. The key point is the student then needs to decide what he or she needs to do. They could, unfortunately, they can't switch to a skilled worker visa because they've not completed their course, but they could. If there's somebody in the UK that they are in a relationship with, they could get married and switch to that visa. They could, it's difficult, but they could try and find an alternative university sponsor and then become sponsored by the university. They could get their things ready and leave the United Kingdom. They would not be classed as an overstayer at all. They would leave, okay, they've not completed their course, but there's no black mark on their immigration status because they haven't overstayed at all. That then gives them the opportunity to come back to the United Kingdom as a skilled worker. So you're saying, Brother Nadeem, he is your employee. It may well be possible for this person to come back as your employee, as long as the person does not overstay. So there is some positive news out of all this. But thank you very much indeed for that question. The next question that's come in is from Hama. And Hama says, approximately 2 weeks ago, I submitted an application for my wife. I've now received an email from the Home Office. So she applied abroad. They received an email from the Home Office basically saying that any supporting documents should be submitted within 5 working days of the email that he has received. And he says, I've already submitted the documents. Why have I got this email? Now, I understand where you're coming from. Where somebody applies for a spouse visa from abroad, the normal practice is, as far as lawyers are, if you do it through solicitors, they will normally submit your documents straight away. They will upload your documents straight away. Now, whether that's, even if that's been done, and in my experience, in 99% of cases, that's already been done, everybody gets the same email once the application is opened by the Home Office or the processing of the application is commenced. Everybody gets the same email, and the email will say, if it does actually say, if you look at it closely, if you haven't submitted your documents, you need to submit your documents within 5 days. So if you have, you don't need to do anything. A lot of people will panic thinking, I've submitted my documents. Why am I getting this kind of email? Is it that they haven't received it? Is there a problem? But there isn't. Look, this is a standard email that everybody gets. But thank you very much indeed for that question. The next question we've got is from Brother Tasawwur. And he says, I submitted an extension application from within the UK. I submitted using the fast track priority, the 24-hour service. I haven't received a decision today. How long does it take to get a decision? Now, Brother Tasawwur, the fast track priority service, in terms of the next day service that you're talking about, in my experience, you might get the decision the same day, or you might get the decision the next day. Occasionally, it takes another day for the decision to be made. Generally work on the basis that it normally takes 1 to 2 days. If it's a very straightforward case, you might get the decision straight away. And it's not unheard of for somebody to submit the application, have their biometrics enrolled at 10 o'clock in the morning, and by 1 or 2 o'clock they're driving home or whatever. 1 or 2 o'clock they've got their message saying your visa application has been approved. Now that happens, fine. But sometimes cases are looked at under the priority service, they're accepted under the priority service, but they are slightly complicated. So it can sometimes take 24 hours, 48 hours for the decision to be made. Occasionally, and if this is a case with your application, there is a complication, then they will tell you that, you know what, your case is slightly complicated and we can't make a decision straight away. We have considered your application as we're obliged to do using the priority service. We can't make a decision because we want X, Y, and Z. You supply it, and then they do take then a little longer. It's still quicker than a normal application, you've not got your decision within 24 hours or 48 hours. They've asked for more documents. They are going to consider those documents and make a decision. So instead of getting a decision within 1 or 2 days, it's now taken around 5 days, 10 days. It does happen. Paying that extra money does not give you an absolute guarantee that the decision will come through by the same day or within 24 hours. Sometimes it can take a little longer. And I completely understand that that is frustrating, especially where the Home Office is charging an extra £1,000 for priority. It's a lot of money, and you would expect that they would at least come back to you straight away that day or within 24 hours, but it doesn't always happen. But thank you very much indeed for that question. Now, actually, we've had a number of interesting questions coming in throughout the day, which I've tried to go through. The next question that's coming is from Hummer, and it's quite a long question. I might just try and condense it. And she says, I want to ask about a friend who's had some difficulties with his case. He has a child in the UK, and he has a case in court to be able to have contact with the child. In addition to that, he's got an application in the Home Office for a visa. It's been 9 months, he's not heard anything. Is there anything that can be done? He spent a lot of money on the application already. Now, in my experience, these are cases which take a long time, especially, and I'm assuming that this is a standard application which has been submitted. So this is an application where an assuming husband and wife have split up. The applicant, the husband, I'm assuming, has a child who's British. He doesn't have contact with the child or access to the child, and he's started court proceedings in order to get access to the child. He's already also got an immigration application pending for leave to remain, and that's been ongoing for 9 months. Now, what will happen is they are both connected. In most cases, he needs a court order saying he can have contact with his child. He needs that for his immigration application. If he gets that, he can use that in his immigration application to say, I need leave to remain in the United Kingdom because because I've got a court order allowing me access or contact with my child, and I could only exercise that really if I'm in the United Kingdom. So they're both connected, and 9 months for either of those cases is not very long. Family law cases, where they get complicated, easily take a year and a half to make some progress to get to the stage where somebody's got some kind of contact. And as far as the immigration application is concerned, it's not unusual for an application which has been made on the basis that, the relationship has broken down, but I'm having contact with my child. It's not unusual for that application to take around a year. Now, practically, I'll be honest with you, what's going to happen is this. The Home Office will say, can we have a look at the contact order? Because once the contact order is there, that will allow you to be granted a visa on the basis that you can have contact with the child. If the contact order is not there, your lawyers are going to have to go back to the Home Office and say, look, the contact order application is still pending, this is where we are, this is the court documents, can you hold off? The Home Office in that situation has two options. They can say, you know what, we're going to put this application on hold. You sort your visa out, we'll give you 6 months, whatever, and then we can then give you a visa Or they could say, you know what, you're involved actively in proceedings. So what we're going to do, we're going to give you a visa for 1 year. And that then means that, you know, you've got a year, sort out your proceedings. Once they're sorted out, assuming you've got contact, you can then apply for a visa again based on that contact order. So the delay in this kind of case is not unusual. It does happen. You, in one sense, the delay is helpful because you need that contact application to progress to a stage where your friend does get contact, because that's necessary for the immigration application. Once that's granted, a visa should be granted. Worst case scenario, the Home Office will say, look, it looks like you're actively involved in proceedings. It wouldn't be right to send you back in that situation. We'll give you a year's visa so that you can then continue pursuing those proceedings and then come back to us and make another application. Expensive business, but what can you do? You paid money for this initial application. In a year's time, when you've got your contact order, you're going to have to make an application again. Expensive business because we are in a situation where you're spending, you know, a lot of money on these applications, £3,800 or whatever it is, 3,885, whatever it is. They're big chunks of money, and especially if you've got family law proceedings ongoing at the same time, they are extremely costly, where you have multiple hearings, and if you've instructed a lawyer, it's costing you for each hearing. So Hama, thank you very much indeed for that question. It's not unusual. Carry on fighting, and hopefully you will get a positive result soon. Now, I think we are coming towards the end of the show, but mashallah, we've had a lot of interesting questions coming in today, a number of different immigration questions. Jazakallah, thank you very much indeed for those questions. If you've asked a question and you're still unsure about the answer, please leave your number with the control room and I'll come back to you. That brings us to the end of the show. Inshallah, we should be back next week at the same time. Until then, Assalamu alaikum. Jazakallah, thank you.